In the rapidly evolving landscape of artificial intelligence, few issues have ignited as much controversy and debate as the recent legal battle between major entertainment corporations, including Disney and Universal, and the AI company Midjourney. At the heart of this lawsuit lies a fundamental question: what is the role of AI in the creative industries, and how should intellectual property laws adapt to this seismic shift? The implications of this case ripple far beyond courtroom arguments, reaching into the core of artistic creation, economic livelihoods, and cultural heritage. The lawsuit accuses Midjourney of infringing on copyrights by using proprietary artworks to train its AI models, which in turn generate new images inspired by this dataset. On one hand, corporations argue that their protected creative works are being exploited without permission or compensation, threatening the value of their IP. On the other hand, proponents of AI-generated art contend that such technologies democratize creativity, enable novel forms of expression, and challenge outdated legal frameworks. This case unfolds amid broader trends where companies like Disney and Universal are aggressively automating their creative processes, increasingly replacing human artists, animators, and designers with AI-driven tools. The irony of these same corporations suing an AI firm raises profound questions about corporate strategy, labor rights, and the future of creativity. This video seeks to unpack these complex issues over multiple sections. It explores how the lawsuit might reshape the arts sector and IP law, the paradox of corporate AI adoption alongside legal opposition, the broader social and economic impacts, and ethical considerations around AI in creative work. It also reflects on cultural shifts prompted by AI-generated content and the need for equitable, forward-looking policies that balance innovation with human dignity and artistic integrity. Intellectual property law was crafted in an era of human-centric creativity. Artists, writers, inventors, and musicians producing original works protected by legal rights granting them economic control and moral recognition. Copyrights, patents, and trademarks aim to incentivize innovation by rewarding creators while eventually enriching the public domain. However, AI-generated works disrupt these assumptions by introducing non-human agents in the creative process. Central to this disruption is the question of authorship. Legal frameworks traditionally require a human author for copyright protection. AI systems, however, operate autonomously or semi-autonomously, synthesizing new content by analyzing vast datasets often composed of copyrighted works. Does this process amount to original creation, or is it mere imitation or transformation? Who deserves credit and ownership? The AI developer, the user directing the AI, or the original artists whose work trained the model? These questions are far from theoretical. The outcome of cases like the Midjourney lawsuit will establish precedents that shape IP law's trajectory. Courts must grapple with balancing rights holders' interests against the potential of AI to augment human creativity and lower barriers to entry. The legal ambiguity creates a chilling effect for artists uncertain about how to protect their works, while also stifling innovation from AI developers fearful of costly litigation. Moreover, AI training datasets often include works scraped from the internet without explicit licensing, raising ethical and legal issues about consent and compensation. This data mining practice challenges the fundamental principles of IP law, which emphasize creators' control over the use and distribution of their work. In sum, AI compels a rethinking of intellectual property from the ground up, demanding legal reforms that acknowledge the hybrid nature of AI-assisted creativity, protect artists' rights, and foster innovation that benefits society as a whole. One of the most striking aspects of the Disney-Universal lawsuit against Midjourney is the paradoxical relationship these corporations have with AI. On one hand, they seek to halt AI companies that use their IP without permission. On the other hand, these very companies are aggressively investing in AI technologies to automate creative tasks, reduce labor costs, and accelerate content production. Disney, for example, has explored AI for animation, scriptwriting assistance, and special effects generation, aiming to streamline workflows and enhance productivity. Universal similarly leverages AI to generate trailers, visual effects, and even music. This trend reflects broader corporate strategies prioritizing efficiency and profitability through technological adoption. However, this shift comes at a significant human cost. Increasingly, roles traditionally held by skilled artists, animators, and other creatives are being automated or outsourced to AI systems. This raises critical labor questions about job displacement, de-skilling, and the erosion of professional creative communities. While AI tools may augment human creativity, they also risk supplanting workers and concentrating creative power in the hands of those controlling the technology. The lawsuit thus encapsulates this tension between embracing AI for competitive advantage and defending existing IP assets as a hedge against loss of creative control. It reflects a broader dilemma faced by many industries disrupted by AI, balancing innovation's promise with the ethical imperative to protect workers' rights and cultural value. This paradox underscores the need for a holistic approach that integrates IP reform, labor protections, and ethical AI development, ensuring technological progress does not come at the expense of human creativity and dignity. The lawsuit against Midjourney and similar AI companies has cast a spotlight on the precarious position of artists and creative professionals in the digital age. While AI-generated art promises new possibilities, it simultaneously threatens the economic and social foundations of many creators' livelihoods. This section delves into how AI disrupts traditional creative labor markets and explores the nuanced implications for artists worldwide. Artists have historically relied on the uniqueness of their style, vision, and craftsmanship to earn a living. Intellectual property rights serve as a legal and economic safeguard, allowing artists to control how their works are used and monetized. The rise of AI challenges this model in multiple ways. Firstly, AI's ability to produce high-quality artworks rapidly and cheaply undercuts the market for human-created art. Clients and companies may prefer AI-generated content due to lower costs and faster turnaround times, resulting in reduced opportunities for human artists. This dynamic risks commoditizing creativity, treating art as a mass-produced product rather than a unique expression. Secondly, the training of AI models on artists' copyrighted works without their consent raises questions of exploitation. Creators whose works form the backbone of these datasets see little to no compensation or acknowledgement, fueling resentment and calls for greater transparency and fairness. The blurred boundaries between inspiration, copying, and theft exacerbate tensions in the creative community. Thirdly, the rise of AI-generated art complicates notions of artistic identity and authenticity. If a machine can imitate a famous artist's style flawlessly, what distinguishes genuine creativity from replication? This philosophical quandary influences market values, artistic reputations, and public perceptions. Nevertheless, some artists embrace AI as a tool for collaboration and experimentation, harnessing its generative capabilities to push creative boundaries. These early adopters highlight AI's potential to democratize art making, enabling broader participation beyond traditional gatekeepers. Policymakers and industry stakeholders must recognize the diverse experiences of artists and develop supportive frameworks. Potential solutions include fair compensation models for artists whose work trains AI, strengthen labor protections, and initiatives that foster human-AI collaboration without exploitation. Ultimately, safeguarding the creative workforce amid AI's rise is essential for preserving cultural vitality and ensuring that artistic labor remains valued and sustainable. A pivotal aspect of the Disney Universal lawsuit centers on the legality and ethics of how AI models are trained, particularly the use of massive datasets scraped from the internet, including copyrighted works, without explicit permission. This section examines the complexities of dataset curation and the implications for intellectual property law and ethical AI development. Modern AI models learn by analyzing vast collections of images, texts, or sounds, identifying patterns and styles that inform their generative capabilities. Much of this training data is gathered automatically via web crawling, aggregating publicly accessible content without filtering for copyright status. From a legal standpoint, this practice raises serious concerns. Copyright holders argue that unauthorized use of their work for training purposes constitutes infringement. However, current copyright law offers ambiguous guidance on whether such data mining or fair use exceptions apply, especially when the training process results in AI-generated outputs derivative of the original works. Ethically, the lack of consent and compensation for artists and creators who unwittingly fuel AI models is troubling. It suggests a power imbalance where tech companies exploit creative labor while externalizing costs and risks. Some AI developers advocate for open access and innovation, emphasizing that restricting data use could stifle progress. They argue that AI-generated content is transformative and distinct enough to warrant protection under fair use doctrines. Resolving these tensions demands legal clarity and new frameworks that balance innovation with creators' rights. Possible approaches include establishing licensing systems for dataset inclusion, mandatory attribution, royalty payments, or opt-out mechanisms for artists. Transparency in dataset composition and training methodologies is also critical for accountability, allowing creators and the public to understand how AI models function and how their work contributes. This debate reflects broader societal challenges around digital ethics, data ownership, and the role of consent in an interconnected world where boundaries between human and machine creativity blur.